Good afternoon, ladies and gentlemen, and welcome to this webinar on legal, operational, and tax issues in securitization. I'm Sandhya Iyer, based out of the Mumbai office of Vaish Associates, and my areas of practice are banking, structured finance, IBC, and corporate advisory. So why is it that we have chosen this topic of securitization today? So in today's circumstances, on the one hand, we have the NBFCs who are facing a funds crunch. And on the other hand, we have the RBI, which has recently taken several measures to improve the liquidity of the banks and incentivize them to increase the credit flows. Now we expect the securitization transactions to go up. Simultaneously, the IBC is now more than 3 years old, and we've had several learnings in the process, especially in the area of bankruptcy remoteness. So we just thought that this would be the right time to share our experiences on securitization. Now, the format of this webinar is that I will be covering PTC structures and NPA purchases. Manish will be speaking about direct assignment. Priyanka will cover direct tax implications, and Arnav will speak on GST implications. Now, to start with, for the benefit of those who have been introduced to securitization in the last 5 or 10 years, I would just like to spend a few minutes sharing my experience of how the securitization market has evolved over the years. Now, we are all aware that Citibank is the pioneer of securitization in India, and the first securitization deal took place in the year 1991 when Citibank raised around 16 crores from GIC Mutual Fund by securitizing some of its auto loans. And 16 crores was a huge sum in those days. So what exactly is securitization? If you have, say, HDFC Bank, which has lent to a lot of borrowers, say, car loans, and they want to sell a pool of car loans to, say, State Bank of India. So they execute documents and sell it to State Bank of India. This is called a direct assignment. An alternative available to HDFC is HDFC transfers this pool of loans to a trust. The trust in turn issues pass-through certificates to various investors. So these investors, I mean, the most common investors that one comes across are banks and mutual funds, but it could also be pension funds, provident funds, or insurance companies. Now, one thing that we have to understand that any pool that we transfer will not be perfect. There will always be some defaults in every pool. So what happens is when there are defaults in the underlying pool, from the borrower, you do not receive the payment. There is a shortfall in funds available for investor payouts to the investors. So how do you protect here? So in securitization structures, what you have is the concept of credit enhancement. The seller of the loan provides a credit enhancement, and this credit enhancement is used to meet any shortfalls in investor payouts. So let us understand what are the types of credit enhancements. So there are basically two types of credit enhancements. One is external credit enhancement and the other is internal credit enhancement. When it is external credit enhancement, the two most popular types of credit enhancements are fixed deposits and guarantees. So here what happens is you have a pool which you have transferred to an assignee, and the borrower, there are a few defaults, say 7% defaults in payments. So what you do is you draw from the FD or you invoke the bank guarantee and use the money to meet the investor payouts. After you make the payouts, it's possible that the borrower may pay but a little late. The payments which come in will be used to replenish the credit enhancement. So this is the basic concept of external credit enhancement. Apart from external credit enhancement, you also have internal credit enhancements. And what is internal credit enhancement? See, there are basically two types. One is subordination of opening overdues and the other is excess interest spread. And let me quickly explain these concepts. So what is opening overdues? The day on which you transfer the pool from, say, HDFC Bank to State Bank of India. As I said, pools are not perfect. There will be some opening overdues. So you will transfer the opening overdues as well to the assignee, and if there is shortfall in cash flows available for investor payouts, it is drawn from the opening overdues. And if suppose there is no shortfall, the opening overdues will periodically be refunded to the originator. And what is excess interest spread? Excess interest spread, the concept is, okay, HDFC has a pool of loans that it is going to sell. So its average return on the pool is say 10%, and HDFC has managed to find an investor who's willing to invest say at 8%. So what happens is this 2% differential is called excess interest spread. This excess interest spread is utilized to meet the cash flows, shortfall in cash flows for investor payouts. And suppose the pool is doing well and there is no requirement of this excess interest spread, that will also be paid out to the originator. Now, one thing we have to remember is that under the current regulations, you are allowed to provide, the originator is allowed to provide credit enhancement once in the initiation of the transaction only. Now, coming back to this concept of securitization, we have been, doing these securitization transactions for about 30 years in India. And what I find most amazing about this product is the very little litigation that you will find on this subject. Otherwise, India is a very litigious country, and on every issue you will find several case laws. But you search for case laws on securitization and there are hardly any judicial precedents that you will find, just maybe a handful of them. And I've often pondered over the reasons for this, and the answer that I feel is the correct answer is that this securitization experience of ours has been basically in retail loans, whether it be home loans or car loans or commercial loans, vehicle loans, two-wheeler loans. And generally our Indian middle class is basically honest and does not like the stigma of default. And I suppose that is one of the important reasons for very less problems with the securitization. The other reason could be that in our securitization, most of these portfolios are backed by good quality assets, and you can enforce it by repossessing your assets instead of long drawn battles in courts. So I hope this continues, and after COVID-19, nothing changes and our economy recovers quickly and there are no adverse consequences on the securitization market. So I would just go back now to the history of securitization. Before 2006, securitization was not regulated and we were free to experiment with all kinds of complex structures. It was on 1st February 2006 that RBI issued the guidelines on securitization of standard assets. So initially there was a lot of displeasure about these guidelines because nobody likes to be regulated and everybody wants full freedom to do the business the way they like. However, the best part about the RBI guidelines of 2006 was that for the first time it introduced clarity on the concept of true sale. So earlier we were not very sure before 2006 as to how courts would look at securitization structures and how they would determine whether a particular transaction was a true sale. So with the 2006 guidelines, we were confident that once we meet the RBI prescribed criteria for true sale, and Manish will be covering this in his presentation, then we would be able to easily convince the court should there be any disputes. Now, another feature about these 2006 guidelines was that it mentioned only securitization and there was no reference at all to direct assignment. So what would people do those days? A lot of the stakeholders would say, okay, fine, I will follow the basic spirit of the securitization guidelines when I do direct assignment. And the others would say, no, direct assignment does not apply to me and I will not follow the guidelines. But of course, some of the bankers have told us that in private communications with them, RBI had always informed them that even for direct assignments, the spirit of the securitization guidelines have to be followed. So this was in 2006, and then came the year 2008, where there was the global subprime crisis. So the root of this crisis was the indiscriminate mortgage lending without proper credit appraisal and complex securitization structures. And the problem was more in US and certain foreign countries. Fortunately, the Indian securitization market was relatively unaffected. But even then, RBI immediately felt the need to introduce further checks and balances to ensure that this would not happen in India. And they first came out with a discussion paper in the year 2010, which culminated in additional guidelines for securitization, first for the banks in May 2012, and then for the NBFCs in August 2012. So I think it is a very interesting to study the restrictions imposed at the time, that is in the year 2012, against the background of what was the securitization practices prevailing in India then, as well as from the learnings of the global subprime crisis. So what did the 2012 guidelines do? So one of the first steps introduced was by these guidelines was they introduced the concept of minimum holding period and minimum retention requirement. So by minimum holding period, it means that you hold a loan for 6 to 12 months after you disburse the loan, depending upon the tenure of the loan, before you sell the loan to somebody. And the objective was that you see a minimum recovery performance, which is demonstrated clearly before you securitize the loan. What was minimum retention requirement? Minimum retention requirement was then when you sell a loan, you ensure that throughout the tenure of securitization, you have an exposure of say 5 to 10%, so that you're careful in appraising the credit of the borrower before you securitize, and you have a skin in the game. In fact, before 2012, there were also instances where even project loans would be securitized even during their gestation, before expiry of their gestation period. And RBI was then of the view that banks and financial institutions were better placed to handle project implementation risks, especially in case of infrastructure project. And this risk should not be passed on to investors. So the 2012 guidelines also prohibited this. Now, what were the other features that were banned in the 2012 guidelines? So the first ban was on synthetic securitization. So synthetic securitization, these can be very complex structures as seen in the international market, but I will try to explain this in a very simple manner. So I gave the example of HDFC Bank. So suppose HDFC Bank had mortgage loans. So in a securitization, what HDFC Bank does is it actually transfers the loan pool to say a State Bank of India or a securitization trust. Whereas in a synthetic securitization, it would not do that. So it would identify somebody, some institution who's willing to guarantee that the defaults in this loan portfolio, and in return for the guarantee, HDFC Bank would say pay them either a commission or some kind of compensation of fees in a periodic basis. So during the term of the securitization, which is 5 years, the guarantor says that, okay, if there is a default in your pool, I will pay up. And in return for this, you have to pay me regular cash flows on a monthly basis or whatever. So this used to be the structure. And what would the guarantor do? Guarantor in turn would repackage this whole thing and sell it to investors. So what happened in the global subprime crisis was a lot of these, when the credit appraisal of the original mortgage borrower was, poor, and they defaulted, it affected the whole chain, and a lot of them suffered losses and collapsed. Now, fortunately, at least I have not come across any synthetic securitization before 2012 in India, but based on the global experience, RBI in the 2012 circular banned synthetic securitization, which is the position even today. Then another issue was there was a ban on securitization of revolving facilities. So before 2012, we did do securitizations of cash credit balances, credit card receivables, but these were prohibited from 2012. Apart from this, assets purchased from other entities. So if HDFC Bank transfers its loan pool to State Bank of India, then it is not permitted to securitize what it has. State Bank of India is not permitted to securitize what it has purchased from HDFC Bank. So there was a ban on this one, securitization of assets purchased from other entities. The fourth one was single asset securitizations were banned. What is single asset securitization? So those days, single asset securitizations was very prevalent. So what would happen is you would have a lender who had a very good relationship with, say, a corporate or a PSU. And what they would do is they would tie up with the lender and disburse them a huge loan. So the loan is disbursed today, and the same day or maybe in the next couple of days, it is securitized and packed off to certain investors. So what was the problem that RBI had with this? For this, we have to understand the human psyche. So when an asset belongs to me or when a thing belongs to me, I'm very careful about that thing. But when it belongs to somebody else, perhaps I may not be that careful. So the concept here was different, was similar. So what happened is when a bank originates a loan for the purpose of keeping it on its books for 5 years, the bank will be very, very careful about credit appraisal. But when a bank originates a loan with the objective that I'm going to sell it now or in the next 2 days, and the benefit for me is only the huge fees that I earn, there is a possibility that they may compromise on credit appraisal and pass off these loans to gullible investors. So that was what RBI did not want. And so they have banned single asset securitizations, which is the position even today. Now, the next issue is they prohibited credit enhancements for direct assignment. So in the beginning, I had explained to you how there is direct assignment and there is securitization. So before 2012, you saw a lot of direct assignment transactions where there was credit enhancement. But in 2012, RBI said that, you know, the investors or the buyers in case of direct assignments are generally financial institutions who have the necessary expertise to appraise the loan. There is no need to provide a credit enhancement for them, and they can bear the loss if there is any. So again, that continues even today. And finally, there was re-securitization, which was prohibited in the 2012 guidelines, which continues even today. So what is re-securitization? So before 2012, we would see structures where, let me give an example. So say A was holding pass-through certificates issued by Trust X, and the underlying pool was a car loan pool. B would hold pass-through certificates where the trust was Trust Y and the underlying assets were commercial vehicles. And C was holding, say, pass-through certificates where the trust was Trust Z, underlyings was three-wheeler loans. So what would A, B, C would come together and they would transfer their PTCs to a new trust. And this new trust would issue further PTCs to new investors. So what was the reason that RBI banned this? One of the reasons was, one of the problems in the subprime crisis was this multiple securitizations. So the problem is, if you do the multiple securitizations, the ultimate investor will not know what is the pool that he is exposed to and what is the borrower that he is exposed to. And that is why RBI imposed this ban on re-securitization. Now, when these 2012 guidelines came out, many of us were very unhappy with RBI, and we called it over-regulation and killing the securitization industry. However, it's been 8 years since the 2012 guidelines, and we have survived. And maybe the securitization market has not grown as much as we would have wanted it to grow, but it's not been a bad growth. So, as per an Economic Times report for the period 9 months period ended December 19, there were PTC securitizations for about 64,000 crores and direct assignment for about 93,000 crores. Now, let me just speak about the various types of transactions. So all that I have been telling you about these regulations apply to performing assets only. So apart from performing, and in performing assets, there can be direct assignment, there can be securitization. Apart from performing assets, you can also assign non-performing loans. And for assigning non-performing loans, there is a separate set of regulations. So even in non-performing loans assignment, you have the same thing. You have direct assignment, you have securitization of the non-performing loans. And in this, you have another very important player, which is the asset reconstruction companies. So when asset reconstruction companies, when they purchase a loan when from a bank and it is transferred to a trust and security receipts are issued, in the case of ARCs, the nomenclature is security receipts and not pass-through certificates. So what are the regulations that govern the purchase of non-performing assets? As far as ARCs are concerned, it is the SARFAESI Act and Securitization Companies and Reconstruction Companies Guidelines of 2003. And when it comes to non-ARCs, there is an RBI guideline on sale of stressed assets for the banks, and there is NPI assignment circulars of 2005. So the interesting part about these RBI guidelines on sale of stressed assets is that these banks can sell their stressed assets not only to ARCs, but they can sell it to other banks, NBFCs, FIs, and other private players as well. And as far as our IBC experience goes, we have seen some really astute buyers who are not neither FIs or ARCs who have bought such loans from banks in India. Now, one of the cousins of securitization is factoring, and factoring is nothing but it's a method of receivables financing. I will not dwell too much on this one, factoring, and the reason for that is that the only reason why I wanted to mention is in factoring also quite often you do see a deed of assignment. Now, when it comes to NPA and ARCs, in the year 2016, the SARFAESI Act was amended to permit that the deed of to provide that the deed of assignment, which is executed for transfer of the non-performing loans to the ARC, if the ARC was acquiring it for the purpose of asset reconstruction or securitization, the deed of assignment is exempt under Section 8F of the Indian Stamp Act. Now, there is a small problem with this exemption, and the problem is this, that this notification has been given under Section 8F of the Indian Stamp Act. As many of you know, as far as state governments are in India are concerned, they are authorized to impose the stamp duty on the deeds of assignment. So some of these states follow the Indian Stamp Act and Section 8F, and they are able to avail the benefit of this amendment to the SARFAESI. But there are many states which have their own state stamp laws, and they do not follow the Indian Stamp Act. And unless they either issue a notification or amend their stamp acts, it is always going to be debatable whether the benefit of this exemption under SARFAESI is available to them or not. So whilst I'm talking about stamp duty, I would like to mention two recent judgments. One of them is the judgment in Kotak Mahindra Bank versus State of UP. What had happened in this case was a deed of assignment was executed in Mumbai by Kotak Bank in favor of State Bank of India, where 48 NPA accounts were transferred. And as is the position in Mumbai, a stamp duty of 1 lakh rupees was paid in Mumbai under Article 25. This one got into the hands of the UP stamp authorities, and they referred the question of law to the Allahabad High Court. And the issue before the Allahabad High Court was whether the deed of assignment should be stamped as a conveyance under Article 23A or B, which would have been a very high figure, or whether it should be stamped as an instrument of transfer of an interest secured by bond or mortgage under Article 62C, which was a nominal amount. So the interesting part here is UP stamp authorities took up the argument that you, Kotak Bank, when you executed this deed of assignment in Mumbai, you paid the stamp duty under the exemption available under Article 25, which pertains to transfer of immovable property. But you are now coming here to UP and saying that this is not a conveyance. And in Mumbai it was a convenience, but here in UP it is not a conveyance, but it should fall as an article under Article 62A as a transfer. So despite this, I mean, there is a detailed, interesting judgment the Allahabad High Court held in favor of Kotak Mahindra Bank, and they said that the applicable stamp duty is under Article 62C. Now, what has happened is the UP revenue authorities have filed an SLP against this before the Supreme Court. And there is something interesting in the Supreme Court proceedings. This was filed in 2018, adjourned from time to time. And in the hearing on 5th March 2020, this Supreme Court has given direction. So what the Supreme Court observed was that in the state of UP itself, when asset reconstruction companies execute a deed of assignment in their favor, when it's executed in their favor, the stamp duty is capped at 1 lakh. So what the Supreme Court said is, just like ARCs, even Kotak is buying NPA from somebody else, and this is its regular business apart from its regular banking business. And Supreme Court also observed that Gujarat and Maharashtra have provided a cap for banks. So they have directed the UP government on 5th March 2020 to consider whether they can extend this cap to banks as well. And the matter was posted for 13th April. This will be an interesting judgment to follow, should be decided after the lockdown is lifted. Now, the second judgment that I would like to refer to on stamp duty again is RSIL versus Chief Controlling Revenue Authority, which was decided by the Gujarat High Court. So in that case, what happened was non-performing assets were assigned by Oriental Bank of Commerce in favor of RSIL, and which was also registered before the sub-registrar Bharuch. Now, this deed of assignment, it fitted into two descriptions because it had a Schedule 3 where there was a power of attorney. So the issue before the court was whether this power of attorney, which also had certain provisions for going and admitting execution before the sub-registrar, whether this should be treated subjected to separate stamp duty under Article 45F of the Bombay Stamp Act that is applicable in Gujarat. And this is applicable whenever any power of attorney is given for consideration and authorizing the attorney to sell immovable property. So unfortunately, the Gujarat High Court has held against RSIL, and again, this is also before the that is an SLP filed, and the matter is before the Supreme Court. This would also be a very interesting decision to be following. Now, let me come to the issues arising out of COVID-19 in securitizations. So, as all of us are aware, RBI by circular dated March 2027, March 2020, had granted moratorium of 3 months on repayment of term loans. So what happens to our securitization structures? Because there is a moratorium, there is going to be a shortfall in our cash flows. So one worry where I have not seen any kind of explanation or clarification by RBI is, see, the PTCs, if payments are not received after till a stipulated period, I think it is 90 days, then they become non-performing assets. So I think RBI needs to clarify that the moratorium period of 3 months will be excluded while deciding or determining whether the PTCs are non-performing or not. This is one issue. And the second issue is that in all securitization, the PTCs have to be compulsorily rated every 6 months. So the worry here is when there is a moratorium, obviously there is a delay in investor payouts. So it shouldn't be that some rating agency downgrades the rating of this PTCs. See, these PTCs are always associated with the originator, and once issue floated by you is downgraded, maybe it will create problems in your raising, or doing more securitization deals in future. So what I think RBI needs to do, and I don't know whether any of the stakeholders have made a representation to RBI on this, but I think we need to make a representation to RBI that, these are special, extraordinary situations, and as a one-time measure, the originators, if they wish to, should be permitted to provide additional credit enhancement in order to ensure that there is no rating downgrade in respect of these PTCs. The next issue that I would like to discuss is the issue of NBFCs. All of us know that NBFCs are going through a very, very difficult time. So what are the problems that one could, face when one buys a loan from an NBFC? So the first problem, which, when our going was very good and the economy was doing well, we all tended to ignore. See, how do these NBFCs raise finance? What they do is they hypothecate the receivables due from their borrowers and the assets charged by their borrowers to their lenders, to the lenders of the NBFC for the purpose of securing the loans that they have taken for their requirements. Now, after they have done this, now if you see the language of these hypothecation agreements, they will say that there is a charge on all present and future movable property. And after this charge, what happens is we assign this portfolio in a securitization or a direct assignment transaction. So what is the implication of this? So tomorrow, if the NBFC gets into financial difficulty, the existing lenders will come and tell the assignee, look here, when you bought that portfolio from the NBFC, I had a charge over it. So you have purchased the portfolio subject to my charge, and you cannot get a better title than the NBFC. So I will first recover my money from these assets which are transferred to you, and whatever is surplus only goes to you. So this is one risk that you face, and you have to be very careful when you're dealing with NBFCs which are in financial difficulty. What is the second risk? The second risk is the credit enhancement that we take in the form of fixed deposits. So suppose I have taken a credit enhancement in a securitization portfolio from a non-NBFC. So what happens with this credit enhancement, which is in the form of the FD? Is it in the name of the selling banker or selling NBFC, or is it in the name of the trust? So in all the cases, what happens is this FD is in the name of the selling NBFC, and the reason for that is the NBFC says that, okay, this is a credit enhancement, you may or may not have to invoke it, ultimately it is going to come back to me, I would like to retain it on my balance sheet. So it is always in the name of NBFC. Just imagine if such a NBFC is to go into insolvency resolution. So what we have been seeing in IBC is wherever before the commencement of insolvency there has been an FD and it has not been appropriated before insolvency commencement date, the resolution professional takes charge of that FD for his operational requirements. So we have to ensure certain safeguards to see that this does not happen. So this is regarding the NBFCs, and now I would like to come to certain issues that we have been facing in IBC. So one of the first issues is whenever you buy a loan, please, and especially a non-performing loan, because this is what may come, under IBC, please ensure that your deed of assignment is properly stamped and it is properly registered. Otherwise, a resolution professional is entitled to reject your claim. The second issue is, whenever you're buying a pool, study the pool very, very carefully and see that if any of the securities, whether it is principal security or collateral security, which is provided, if the security is owned by a company, please file modification of charge with the registrar of companies. The reason for this is Section 77(3) of the Company Act provides that no charge created by a company will be taken into account by a liquidator unless it is registered and a certificate of registration is given by the ROC. So if you do not modify the charge and the ROC records do not reflect the name of the buyer of the loans, the liquidator would be justified in rejecting the security priority claim. So be careful about this as well. Now, coming to the third issue that I would like to discuss, this is regarding undervalued transactions in the case of IBC. So what happens is, now just imagine that you are buying a pool of loan from an NBFC, okay, and you have to ensure that you are able to demonstrate very clearly that you have paid a fair value for this pool. Suppose an NBFC goes into insolvency, then if you have not paid a fair value, or you're not able to demonstrate that you have paid a fair value, the resolution professional can make an application to NCLT to declare that such transactions are void, and he can reverse the effect of such transactions. Now, the last and the final point that I would like to speak about is preferential transactions under IBC, and for this, let me give you a very example to understand this. Let us take the case of a lender bank. So the bank has given a loan to the NBFC, and NBFC has got into financial difficulty and is defaulting. The quality of the bank's assets is not, security is not very good. So the bank has a lot of clout with the NBFC and goes to the NBFC and says, look, I have seen your portfolio. It cherry picks 20 of the best loans and says that, okay, fine, the dues to me are 100 crores and I have cherry picked this portfolio of yours of 100 crores. So please sell this portfolio of 100 crores to me. So the NBFC says, yes, pay me the cash. So the bank pays the cash to the NBFC. NBFC uses the cash to retire the existing dues of the bank. Please, and we have seen these structures happening. So please note that such transactions would clearly fall within the meaning of a preferential transaction as defined in the IBC. So please be very, very careful while dealing with an entity which is likely to get into financial difficulty or which is already in financial difficulty. With this, I would like to conclude and hand over to my colleague Manish.
Thank you, Sandhya, for very detailed discussion on securitization aspects. Good afternoon, friends. I am Manish Tuli. I am based out of New Delhi office of Vaish Associates, and my areas of practice are general corporate advisory, capital markets, securitization, and acquisitions. In this presentation, I would be discussing primarily about the direct assignment transactions. Before I take you through the issues which we are facing on daily basis regarding when we are doing a direct assignment transaction, I would like to bring to your attention that there is a report of the Committee on the Development of Housing Finance Securitization Market in September 2019, and they have stated that total volume of the housing sector only in India is around 150 lakh crores, and the total securitization volume of the total securitization transaction since 2005-6 to 2018-19 has grown about 11 folds from 25,000 crores to staggering 2,66,000 crores. This is a phenomenal jump in the securitization transaction over a period of about 13 years. Now, we all know that direct assignment transactions are typically not considered as traditionally a securitization transactions per se. But as of now, those guidelines which are applicable to the securitization guidelines are also applicable to the direct assignment guidelines. And as per the report, 75% of the securitization transactions are being done by way of a direct assignment transactions. And direct assignment transactions are thus enjoying the predominant position as of now in the market. Now, a question comes to everyone's mind: what makes direct assignment transactions so lucrative for the sellers or for the buyers? As far as the buyers are concerned, it is very easy for them to quickly deploy their idle funds and to acquire a loan book. Secondly, if your direct assignment transaction is pertaining to housing finance pool, then they can easily acquire a pool of assets which help them in meeting their priority sector obligations. As far as the sellers are concerned, their consideration to do a direct assignment transaction is primarily due to their funding requirements. We all know that if we talk about housing loan transactions, the gestation period of loans are pretty large, 20 years, 25 years, or 30 years. So in order to liquidate those loans and to have ready cash available, many of the Nbs Fees and housing finance company resort to direct assignment transaction and get a ready cash available for their business requirements. So that is an overview of these days the direct assignment transactions happening in India, specifically in housing finance sector. So I will be taking you through critical aspects, or rather I will say operational aspects, which we face on daily basis when we are doing a direct assignment transaction with specific reference to in the housing finance regime. Now, the first and foremost issue which every transaction have is transferability of a mortgage security interest. Now, as we know, all housing loans are secured by way of mortgages, and there is an underlying security in all housing loan transactions. Now, there are two types of structures which are prevalent in the market. One structure which is prevalent in the market is that sellers are going to assign the receivables plus underlying security, but the mortgage security interest is being left with the originator, that is the sellers, for the administrative conveniences. The second structure, which is also now prevalent in the market, is that loan pool is being assigned along with the underlying securities in its entirety and including the mortgage security interest as well. The question comes, why there are two different type of structures available and why there is a debate going on and why councils argue on these two kind of structures. Primarily, there are three aspects related to the transferability of mortgage security interest: is benefit of availing remission on stamp duties. Second, requirement of registration of a deed of assignment. And third, the issue where to get the deed of assignment registered. I will take the remission issue first. There are very few states in India which have given certain kind of remission on deed of assignment. One of the state is Delhi. I think it is Maharashtra, Punjab, Gujarat, and Rajasthan. Yeah. So these states have given remission in the stamp duty. If we talk about Delhi, Delhi has given a remission, and there's a notification of the remission categorically states that for any direct assignment transaction which involves assignment of receivables along with underlying securities, then you can avail the benefit of remission of a stamp duty, and the stamp duty in this case would be capped at 1 lakh rupees. Otherwise, it is around 3%. Now, a question comes whether the word used in the notification underlying security necessarily implies that you have to mandatorily transfer the mortgage security interest, or it can be fair enough even if when you are saying that along with receivables you are transferring security interest, but keeping the mortgage security interest back interest with the originator for administrative conveniences. My view is that these languages are clarificatory in nature. You can take the benefit of this remission notification, whether you specifically assign the mortgage security interest or you leave it with the originator interest. However, yes, there are different arguments to it that no, one must transfer this mortgage security interest as well to claim the benefit of this stamp duty remission. One of the related issue which comes with it is if I'm going to transfer a mortgage security interest, then my deed of assignment will basically become an instrument by which I am creating an interest in the immovable property and trying to transfer that interest in immovable properties. So does it imply that I necessarily has to go for registration of the deed of assignment under Registration Act, which specifically mandates that if you are dealing with the immovable property, you have to get it mandatorily registered? Now, here comes a problem. Though few states have provided a cap on the registration fee, but many states have not yet provided any cap on the registration fee. If I typically tell you about Delhi, though have given an exemption on the remission on the stamp duty, but they have not given any kind of cap on the registration fee, and the registration fee still stands at 1% of the transaction value. Now, there is a substantial exposure of stamp duty and registration fee if your pool size is very, very substantial. So whatever the structure people follow, there is always a tendency to find a safe state which have provided basically a cap on the stamp duty and the cap on the registration fee as well. One of this kind of a state is state of Rajasthan. State of Rajasthan actually has provided a cap on stamp duty and the registration fee for direct assignment transactions, and they have not given any kind of a qualifier about underlying security to be transferred or not to be transferred. They have simply said for direct assignment transactions. In the state of Rajasthan, the cap on the stamp duty is 5 lakh rupees, plus there is a 20% surcharge. So there is an exposure of 6 lakh rupees on the stamp duty part. As far as the registration part is concerned, they have capped the registration fee to 3 lakh rupees. So state of Rajasthan typically becomes some sort of a heaven for all the transactions, and we find a lot of people going to the state of transaction and getting their deed of assignment executed there and get it registered there. But this is also not free from complications. Now, Section 28 of the Registration Act primarily talks about that you have to get your deed of anything which has to do with immovable property. You have to get your deed of assignment registered in a place where either the whole or some of the property is situated. Now, generally, we have seen that loan pool size is very, very big. It may contain about 3,000 to 5,000 loan accounts, and the mortgages are situated in different parts of the country. Few of obviously, if I'm going to the state of Rajasthan or state of Delhi, we must have certain mortgages which are in these states. So we take a benefit of the wordings of Section 28 and say, okay, some of my pool properties are situated in Rajasthan, so I'm getting the deed registered there. But this is not risk-free. One must note that if your deed of assignment is going to a different state, or some people take an argument, there is a Section 65 in the Registration Act, which typically says that it is a duty of the sub-registrar, if they sub-registrar while registering a document find that the jurisdiction of the property lies in two different districts. Mind it, my words are district, I'll come to it. So then it is the responsibility of the registrar to inform the registrar of the other state about the registration being done by them, so that necessary entries to be done by that sub-registrar as well. One school of thought on this is that this is only applicable within the state and where the property is comprised in different jurisdiction of the sub-registrars of that state. One school of thought says it may have even an interstate operation, and thus if I am getting my deed registered in state of Rajasthan, so it is then the responsibility of the registrar of Rajasthan to inform to other states. So unless and until he informs us, I'm good. Practically, we have not come across any case where the documents have been sent under Section 65 to other registrar, and other registrars have really used their powers to ask for the differential stamp duty. But one must note, this is not a risk-free arrangement. If your document is goes to other state, and if suppose sub-registrar definitely informs to the other state, then other state may raise a demand of differential stamp duty. And even in because no state want to lose revenue, if there is an ad valorem duty on the registration, they may even ask that you get your deed registered in their state as well, and then you end up paying a substantial sum of money in different states, and your DA deal actually become non-lucrative. So as a counsels, one has to be very, very clear that when you are drafting a deed of assignment, everyone knows these risks are there. So when you are drafting a deed of assignment, to avoid any kind of conflict between the parties, we must have a very categoric clause in the deed, rather than putting who will bear the stamp duty registration fee as a miscellaneous clause. Rather, I would suggest it should be one of the operational clause which clearly identifies who is going to bear the stamp duty, who is going to bear the registration fee, and in case the mortgage security interest is actually be transferred, who is going to, if the differential stamp duty or registration fee is demanded, who is going to bear the same. So as a counsels, one must ensure that there has to be a very clear-cut provision in your deed of assignment. Here I would like to bring to your attention that these complexities of registration and stamp duty are even highlighted by the expert committee as well in their report of 2019. They have recommended, they have not specifically recommended for DA transaction, they have generally recommended for securitization transactions by saying that stamp duty on the securitizations are to be streamlined and standardized for all the states, and they are to be exempted from the registration requirement. And in order to bring a transparency, the CERSI, which is a Central Registry of Securitization, Asset Reconstruction and Security Interest in India, they should be authorized to register your deed of assignment at a nominal fee. So by this, there can be a transparency on DA deals, and there is going to be a clarity on the stamp duty. And if you are providing exemption on the registration fee, that will set rest all the ambiguities in this field. A second question, related question which comes for discussion is that what will happen if suppose you are not transferring mortgage security interest and you are leaving the mortgage security interest with the originator? Will my security fall away in case of any dispute with the originator? Or generally in India, we have seen the originator act as a servicer. So for all administrative conveniences, all the documents relating to your mortgages and loan documentation remain with the servicer and the originator for enforcement of securities. This threat has become very, very critical point of discussion after DHFL case. In DHFL, what happened that DHFL, we all know, had defaulted in making repayment to their borrowers. And due to that, some of the creditors of DHFL approached High Court of Bombay and procured a stay, whereby DHL is was restrained from making any kind of payments to the creditors, except there is a specific provision in the judgment that they can make some payments to their secured creditors on pari passu basis. By this kind of a stay order, what happened? The DHFL could not even pay their monthly payouts, which they were collecting on the pool assigned by them, and they were acting as a servicer. So this really created a hue and cry in the securitization market, because bankruptcy remoteness is one of the basic characteristics of any securitization transaction. So the people highlighted the fact, is bankruptcy remoteness is truly being applicable in such kind of cases? Though later on, High Court of Bombay gave permission to DHFL to release these payments, but yes, it red flagged the bankruptcy remoteness aspects. So one must ensure that when any such kind of eventualities happens, that one has to bring a provision in your transaction documents very clearly that in what capacity the originator is holding money from you. There has to be a clear-cut distinction that he is not holding any money in the capacity as an owner. They are only holding it as a trustee or as a servicer. Another related question which comes along with this is the borrowers. Can borrowers really object that I am not privy, there is no privity of contract between the borrower and the ultimate assignee? He may say that suppose there is an event of default in the loan agreement, and and the servicer and the assignee want to enforce the security. Can the borrower really claim that there is no privity of contract between me and the assignee, so you don't have any right against me to enforce security? One must understand that in India, we generally have seen that the originators are the servicers. So this may be of a less of a complication, because originator acting as a servicer are always going to be in the forefront to enforce the security. So it will be difficult for the borrower to invoke such kind of an argument. Having said that, one must ensure that, to be very, very safe, that when any company doing an initial loan documentation, when you are entering into a loan agreement with the borrower, your loan agreement should categorically provide that being a lender, you are free to assign or downsell the loan to any entity, any person whatsoever at your free will, and you do not require any prior approval of the borrower or to send any kind of an intimation. If these clauses are there in your baseline loan documents, then it is not possible, or it's not legally plausible for any borrower to say that I have no privity of contract with the assignee and I will not cooperate. They have no right to enforce the security. If these kinds of clauses are there in your loan documentation, then your security will not fall away. But as a counsels, it is our duty, along with the deed of assignment, one must assess what is the language provided in the loan documentation so that one should be very clear that your security is not going to fall off, and the bankruptcy remoteness, which is the true characteristic of any securitization, will hold good. Another important aspect which I want to cover here is collection and payment account. Now, this collection and payment account has also gained a lot of importance due to DHFL issues as well. Now, what is a collection and payment account? It is a very simple account generally maintained by the originator, now acting as a servicer as well. And they keep on collecting receivables as and when they get due from the borrowers. And on the monthly payout date, they make the payment to the assignee in the ratio of their entitlement depending upon their MRR. Now, due to issues involved in DHFL, now the assignees are very, very much concerned that we don't want to continue to use the same bank account which the originator and the servicer are using. Generally, what happens that originators prefer to use their own account because of administrative ease, because there might be some standing instructions or might be auto debit instructions which are given related to the bank account. So they are not interested in opening a new account, because in that matter they have to go back to the borrowers, and they may have to change the standing instructions or auto debit. So they don't want to do it. So they insist that we'll continue to use that same account. But now the assignees are very much apprehensive that what happened in the DHFL case might create a problem if they have a common account which the originator is maintaining. Now, in the recent past, we have seen that the role of assignee representative is now becoming very, very critical. Many assignees want to have an assignee representative, and what these assignee representatives are doing is they are going to open a new account, which is basically a no-lien account managed by the assignee representative, and they will specifically hold all the money into that account for the trust of the assignee. Now, as a signer who is originator may continue to receive money from their borrowers as usual into their bank account, but as and when they receive money from the obligers or borrowers, they have to immediately remit that part to the assignee representative collection and payment account. They keep on depositing that money, so that money becomes identifiable and it is now separated from their own funds. And assignee representative at the end of the period reconcile that money, do their assessment of the receipts, and on the monthly payout date, they make respective payments to the assigner and the assignee. Assigner may be receiving to the extent of their MRR. By this, they are trying to safeguard any kind of issues which involved in bankruptcies issues. And because the money is now separately and identifiably parked separately, so the money would be safe. But no one can guarantee that there might not be bankruptcy issues at the assignee representative level. So tomorrow there might be a case that assignee representative might itself face the bankruptcy issues. So what will happen then? Yes, there is a risk, but considering the fact that this account is a no-lien account and your transaction documents are clearly identifying that this account is being maintained by the assignee representative and they are holding funds in that account exclusively for the benefit of the assignee, the courts definitely need to take cognizance of RBI guidelines with specific reference to bankruptcy remoteness, and must give due regard to those provisions and should not put any kind of restrictions on remittances of these funds in case of any liquidation proceedings or bankruptcy proceedings against a representative as well. Another question which comes to our attention quite often is, because we have seen the originators are primarily the servicers in India. So they come to us and ask whether we can restructure the loan, because we are the front end with the borrowers and the borrower has come to us for restructuring of the loan. Can we do it in our capacity? Or can we give them a top-up loan? Legally speaking, the answer is no, because the assigner is no more the legal owner of that pool. So you have no legal right to restructure the loan per se. Now, one thing one has to understand that the originator and the servicer are the front end and they deal with the borrower on regular basis, and they are in a better placed position to understand whether there is going to be any potential delinquency in the account or not. If they really feel that the borrower has approached them and they fear that there is going to be a potential delinquency, they may obviously go back to the assignee and take requisite approval for restructuring of the loan. But for the ease of doing business or doing minor restructuring, we have seen the parties have negotiated that where the assignees has given some kind of leverages to the servicer to do some kind of basic restructuring. For example, they might have given them that, okay, you can tweak EMIs a bit. You may defer receipt of interest for say 1 or 2 months, not beyond that. Or you, if required, you feel that there is a strong case of delinquency going to happen, then you may even give a bit of a discount of say 0.01% or 0.02%, whatever it is, they put a cap on it. So these kind of structure, we have seen that they provide kind of leverages to the services to restructure the loan account. But any restructuring is to be substantiated with a rationale why the restructuring is done. The second question comes about the top-up loan against the underlying security. Assignees never give permission to the originator or the servicer that you give any top-up loan to the same borrower against the same underlying security, because the top-up loan might not be assigned to the assignee, but simultaneously, if you give a top-up loan against the same security, the originator might be creating a pari passu charge on that underlying security which has already been passed on to the assignee. So top-up loans are generally no for the assignees. Restructuring depend upon case-to-case basis that may or may not be done. Next issue, which is a very important issue for all securitization deals and which Sandhya has highlighted, that true sale is a basic characteristics of any securitization. Yes, even for the DA deals, you have to fulfill the test of true sale. I will read out few specific pointers which basically have to be fulfilled in its entirety to qualify any transaction as a DA transaction. There might be a bit of a difference from the securitization transaction because here we would not be having any kind of a recourse. I'll just tell you that true sale in a direct assignment transaction happen, it must result in an immediate legal separation of the pool from the originator, and should be an absolute transfer from the originator to the assignee. The assets sold should stand completely isolated from the assets of the originator, and the assets once sold should become beyond the reach of originators, including their creditors. This is where the bankruptcy remoteness kicks in. The originator should have transferred all risks, rewards, rights, obligations in the pool which is being assigned, and they should not be holding any kind of beneficial interest in those assets after its sale. They should not have any kind of economic interest in those things. The sellers should not have any right to repurchase the loan pool once sold. They don't have a requirement to fund the repurchasing that loan also, and they have no right to substitute the assets as well. But there is one of the exemption provided that you can repurchase, or the buyer has a recourse against the originator if there is a breach of the representation and warranties given in your deed of assignment. Then yes, the assignee has a recourse against the seller for either for damages or to repurchase it or to substitute the assets. Now, practically speaking, when you are drafting a transaction document, because counsels also need to give a closing opinion at the end of the deal that it is a no recourse deal, it is a responsibility of the counsels that they should ensure that there is no clause, either directly or indirectly, which either provides any kind of direct or indirect recourse which may vitiate a true sale in the document. Now, one important thing which at many times where there may an issue of a true sale about who is going to bear the litigation costs. One must take a care that your deed of assignment must categorically provide that once the loan pool is assigned, the all litigation for the recovery of any of the defaulting loan accounts or any litigation pertaining to those accounts, entire litigation cost is to be borne by the assignee. There should not be any kind of a recourse provided that where assignee is trying to recoup the litigation cost from the assigner. So it basically, if there is any kind of recoupment of the litigation cost from the assigner, it becomes kind of a recourse for the defaulting loan accounts, which is not permissible. Having said that, there is no impediment that generally as per regular RBI regulations, one has to have a minimum rate of retention, maybe generally 10%. So there is no problem, no impediment where the assigner may be sharing 10% of the litigation cost because 10% belongs to them. But rest all is to be borne by the assignee. Now the question comes, I'll quickly cover how the courts are going to determine a true sale transaction. I will not go into the nitty-gritties of all the cases. I will only come to what is the crux in various cases. Sandhya has rightly pointed out there is not much of jurisprudence in India regarding all these issues. We generally rely on international foreign judgments to find out how the courts are determining true sale or not. So the test is generally the intention of the parties. But the intention of parties is also qualified, provided that the document is not explicitly clear about the transaction. While doing research, I found a very old case of 1954, which I found it very interesting. It is a case of Pandit Chun Chun Jha versus Sheikh Ibadat Ali. Here, Supreme Court basically dealt with an issue where the transaction is a mortgage by a conditional sale or it is an outright sale. So I will read a specific text from the judgment where Supreme Court is trying to analyze what is a test. Supreme Court has said that the intention of the parties is the determining factor, and there is nothing special about it unless it is a class of cases where a document has to be construed in such a manner that the intention is gathered in the first place from the document itself. It further said that if the words are express and clear in the document, effect should be given to those rather than making any unnecessary inquiries. So the genesis of this judgment is, if your document is a speaking document and court can decipher what is the intention of the parties from the document itself, so the document will become the paramount document for determining the true sale. But if the document is a complex one and it is not coming out with a clear picture, then one may have to see the surrounding circumstances and then take a conscious call what is the intention of the parties and determine that whether it is a true sale or not. So, as a councils, we have to take due care that there is no recourse to be provided, and the characteristics of true sale in a DA transactions must be met. With this, I conclude my critical points on direct assignment transactions. And now I request my colleague Priyanka Jain to take forward the direct tax issues in the securitization transactions. Thank you, ladies and gentlemen.
Thank you, Manish sir, and thank you for bringing out your expertise around the table. Hi, I'm Priyanka Jain, and I handle direct taxation, advisory, and litigation, and I'm working with Vaish Associates at the Mumbai office. Like any other significant investments, what is the key consideration is what is the return which you earn on it. And along with the return, what arises is the consequential tax treatment, which is prevalent in that jurisdiction. So like any other financial instrument, of course, with the return, the tax is one of the key considerations. Now, the ideal scenario in case of a good tax regime is tax neutrality. So, especially in case of a securitization trust, your tax should be neutral and it should not be a consideration for you to decide whether you want to make an investment into it or not. So it is often acknowledged that taxation, tax neutrality is the key in case of a collective investment vehicle. But the reality is something quite different, and we shall see how. Securitization trust, in fact, before 2013, did not have any specific tax regime. It was taxed as a general taxation structure, and tax was levied in the hands of the trust largely at the maximum marginal rate. In 2013, the income tax enacted the securitization tax regime, in which it laid down that there will be no tax in the hands of the securitization trust, but the securitization trust would be liable to pay additional distribution tax on the income which it distributes to the investor at the rate of 25% or 30%, as the case may be. The investors' taxation consequentially was exempt. However, this created a lot of tax inefficiencies because it was not in the nature of a withholding tax, it was in the nature of an additional distribution tax. So the investor could not claim the credit of the tax. Plus, the rate of tax was not just 25% or 30%. I'll explain you why the effective tax rate was quite high. Is because the income was exempt in the hands of the investor. However, it was again disallowed the deductions which it could have claimed and the expenses which it had incurred in relation to earning that exempt income. So there is a concept of Section 14A, which was largely applied by the revenue authorities, and because of which the effective tax rate was higher than 30%. Plus, in case of foreign investors, since it was not in the nature of a withholding tax, there was a difficulty in claiming credit of this additional distribution tax in their home country. There were certain representations made in the course of time, and in 2016, the securitization trust structure was overhauled, in which the taxation was basically brought to a pass-through level, in which the securitization trust was not taxed. The investors were taxed as if the income had been earned directly by them. The characterization of the income was as in the nature of the hands of the trust. Additionally, in 2016, since they had done away with the additional distribution tax, they brought in a mechanism for withholding of tax when the income was being distributed to the investors. And the withholding tax is still applicable at the rate of 25% or 30%, as the case may be, in case of resident investors. And if we have non-resident investors, then the tax rate would depend on their character and nature, but which could be as high as 40%. So this is what the basic mechanism of income tax or direct taxes on securitization trust. However, there are a lot of unanswered questions yet which are prevalent and for which we're still struggling to come around with that. So I will maybe just raise one or two issues which people still struggle with, and in fact they have also been acknowledged by RBI. So one of the recent issues which have been arising is with the advent of Ind AS. Now, Ind AS 109, which deals with financial instruments, it provides that, as Sanya ma'am and Manish sir had explained about the excess interest spread, you have an excess interest spread in the hands of the originator. As per the accounting standards, the excess interest spread has to be accounted as an income in the year when you enter into the securitization transaction at its net present value. While under the normal income tax provisions, the income is only taxed when it is actually recognized, not in the year when you actually account for it in the securitization transaction itself. Now, why it creates a dichotomy is because tax is also levied on book profits, which is under MAT, which is 115 JB of the Income Tax Act. Now, the book profits do account for this income because of the treatment given by Ind AS, while the normal income tax will still not recognize this revenue because it will follow the accrual basis of accounting. Due to this, there could be an additional tax liability under MAT in the hands of these NBFCs who are liable to apply Ind AS in their accounting books. Banks are still not required to follow Ind AS as of now, but it's quite eventual that in 3 to 4 years time we will have the banks also which will be mandated to apply the Ind AS. The other uneven playing field, as we do not have a tax neutrality in case of securitization trust. Another uneven playing field is the withholding tax rates of 25%, 30% is comparatively quite high. And if we see the interest taxability or the withholding tax rate on other kind of debt instruments like corporate bonds or other debt, they are generally around 10%. And in fact, for listed bonds, there's zero withholding tax. So for non-residents, again, the issue which arises is that this interest income will be subjected to the beneficial rates of the treaty. So because of this high interest rate, the investments in securitization trust becomes little unattractive. The other issue is still about the characterization of income. So when the income is received by the investors, it has to be treated as if in the nature of the income in the hands of the trust itself. Now, the interest income which is earned by the SPV trust, whether it is in the nature of a profits and gains from business, or is it purely in the nature of interest income and hence should be taxed under income from other sources. Now, and because of this unclarity, what happens is that since the investors are liable to be taxed in the same nature, the losses or the income which they have to offer in their return have a differential tax treatment. In fact, in the case of non-residents, if it is treated as business income, they are liable to pay 40% tax rate, while in fact, in case of an interest income, the tax rate is significantly lower. And in cases of non-residents which have a double tax avoidance agreement with India, if you have a business agreement and you can claim that you do not have a permanent establishment in India, there should not be any tax liability arising for you in India. So these are few of the issues which the industry and the sector is still struggling with. Also, there is still a possibility for the government to come out with certain clarifications and amendments surrounding the securitization trust. So with this, I think I will hand over to Arnab to deal with the indirect tax implications.
Thank you, Priyanka. Good evening, ladies and gentlemen. My name is Arnab Roy. I practice in goods and services tax and customs, primarily litigation and advisory. I'm based out of the Mumbai office. So when we talk about the issues surrounding securitization and the impact of GST on it, we have to remember one thing, that investment as such globally, the idea is to keep it as removed from goods and services tax, so that the returns are not eaten into, A, and B, even if there is if GST applicability on such transactions, there should be credit availability on it. So with that, I would like to take you through the past, present, and future in this very brief outline of GST we have had since 2017 and the issue surrounding that. So to begin things with, in 2017, we saw that there was immense lack of clarity as to what would be the correct exemption under which securitization would be fitting into. The minority opinion was that, as a matter of fact, that it should be taxable to the full extent. However, that was not a very reasonable answer. However, the reasonable answers would have been whether it would have been A, it would have been either exempt because it is in the form of transaction securities, or it is in the form of a transfer of actionable claim. Both of these are excluded from the ambit of Indian GST. With that, in 2018 May, the GST Council came out with a clarification wherein they actually clarified that certain securitization transactions would fall within the bracket of transaction and securities, and certain transactions would come in as transaction as actionable claim. With that, they clarified that almost all securitization transaction, as a matter of fact, would be exempt. However, at the same time, they made this very clear that all fees, including servicing fees in relation to securitization transaction, would be exigible to goods and services tax. Now, there comes the major issue as we are facing it currently. Now, when these servicing fees are made applicable to goods and services tax, the credit is either completely lost to the recipient or it's partially lost to the recipient. This actually creates an issue because this basically raises the cost of the borrowing. Essentially, either it basically gets pushed to the borrowers or it is basically gets eaten from the investors' kitty, investors' payout. Having said that, there is another aspect which I would like to focus on over here when talk about servicing fees, is that there is a view that the excess interest spread in the form of in place in SPV transactions and PTC transactions, whether that is actually in the form of a consideration for the servicing that is done by the originator of such loans. Now, one can take an argument, and this has been untested majorly, but I would like to stand with this argument, is that this actually has nothing to do with the servicing aspect of the debts, and therefore it should be viewed as a transaction in money. However, it is expected from the GST Council that they should bring out a clarification in this regard as well. Having said that, let's talk also about the future, where we want to be in the current situation of COVID-19 and our current economic environment. Globally, we have seen that such fees and such excess interest spread has been expressly exempted in the case of EU and in the case of UK. UK calls it as management of credit exemption, and they have actually given very broad outline as to when a fee would qualify in this and when a fee would not qualify in this. So India should explore it. This is where I am being a little prescriptive. Indian GST Council should explore whether they can exempt this fees from the ambit of goods and services tax, because ultimately this will only lead to the cost of borrowing to go up, A, or it would get pushed to the, or B, it would be pushed to the investors, none of which are desirable in the current economic circumstances. With that, I believe that I have covered the issue in very brief. I would like to hand it over back to Ms. Iyer so that we can go through certain questions that we have been receiving.
Yeah, thank you, Arnav. So I find that we have about 10 minutes left, and we will try to answer as many questions as possible. but we would request you that you please do post your questions. You can drop in an email, and we will ensure that each and every question will be responded to at least by email. And we would also like to inform you that, we have an upcoming webinar on practical issues on stamp duty on the 19th of May, where we are planning to structure it in a kind of question and answer format where all the queries regarding stamp duty will be clarified. So if you are interested, please do participate, and you can also send in your questions in advance so that we can review them and answer them to the maximum extent possible. So now looking at the questions. Now, before I start on the questions, like there is one thing that I would like, I have a wish list from the Reserve Bank of India and the Government of India. And see, there have been several seminars and white papers made to the government. It's still not been resolved. But in the interest of ease of doing business, I think one important thing that the Government of India needs to do is there must be uniform stamp duty throughout the country on the deeds of assignment. And just as we've seen these amendments to the Stamp Act, where seeing that, okay, there is a mechanism set up for passing on the stamp duty to the state governments. I think the same should be done in the case of state government, deeds of assignment as well. The second change that I would like to see is make the registration fees for registration, wherever there is underlying securities, which is a mortgage, try to make the registration fees uniform throughout the country. And it should be something very nominal and not high for transfer of or deeds of assignment. Now, if you look at Maharashtra, they have introduced mandatory intimation for mortgage by deposits of title deed. So the same thing can be done for registration of deed of assignment. Instead of us going to, the registrar office and getting it registered, I think there should be a mechanism where online we can go and give an intimation to the respective sub-registrars about these. So it simplifies the whole procedure. And as far as RBI is concerned, like one thing that I would like to see from RBI is this restriction that, assigned loans cannot be securitized. The problem with that is today there are lots of NBFCs who are in problem. So give them the freedom. Same as with the banks. If the bank has purchased a pool from somebody for whatever reasons, it might be priority sector requirements, they should be permitted. Maybe to start with, you permit them to securitize just once. Now with this, let me just go on to the questions. So one question that is asked here is, how does one ensure bankruptcy remoteness of credit enhancement? Yes. So the answer to this question is, like, for example, you have purchased a pool of loans from an NBFC. So you have to be very diligent and watchful. And when you see that the NBFC is getting into trouble, you can take certain steps, and you have to provide for these in your documents as well. One thing is, provide that when the rating falls down below a certain level, then you have the option to convert a fixed deposit into maybe a guarantee, or the fixed deposit which is in the name of the originator, you have the right to transfer it to the security trustee. So this is what I can think of, but one has to be very, very diligent. And the other question that I can see is, can one transfer a loan secured by mortgage by deposit of title deeds? So that is an interesting question, because what is a mortgage by deposit of title deeds? When you create a mortgage by deposit of title deeds, so what am I saying as the borrower? I go and tell the lender, look, here is my title deeds. I am depositing it with you with the intent to create securities for the monies that you have lent to me. And the various courts in India have consistently held that where it is just, there is a document, and which is normally called a memorandum of entry, which just records a past act of coming and depositing the title deeds, that need not be registered. Of course, you now have a few states which have made it mandatory to even intimate or register a mortgage by deposit of title deeds. Yes, so there is a challenge in transferring a loan secured by mortgage by deposit of title deeds. How do you do it? Do you do it by a registered mortgage deed or what? So what I would like to say is, we all think that securitization is a modern instrument, but no. If you go to these old solicitor firms in Mumbai, you will find that they have been doing these transfer of mortgage debts for years together. I mean, maybe some decades back they were doing these transactions. So those days, registered mortgage, there was never any cap, and there would be the only feasible mortgage was mortgage by deposit of title deeds. So in the old solicitor's office, you will still find a template for transfer of mortgage debt, and that will be a very simple document which will, just as in a mortgage memorandum of entry, you say that I deposit the title deeds with intent. Similar language, it will be a two-page document which will say that, okay, initial mortgage was created by deposit of title deeds. Now this is being transferred by constructive delivery or by actual delivery, and the mortgage debt is being transferred. That is also recorded as a past debt. So yes, it is possible to transfer. There are many mechanisms under which you can, depending on the state stamp laws and the Registration Act, there are many mechanisms. There are 2-3 mechanisms under which you can try and secure the transfer of mortgage by deposit of title deeds. So the other question is, okay, Priyanka, there is one question for you, and that question is whether these investors in PTCs, have they been facing any tax problems of late?
Like I said, of course, one of the issues is regarding characterization of income, because that also involves their own individual taxation as regards other income which they are earning from non-securitization receipts. But one more typical problem is regarding that whenever there is a prepayment or a credit tranching, which I understand, the investors who participate in senior tranches, they are generally serviced from interest receipts. A majority of these investors have got taxable income under the current framework. However, when they receive a return on their investments in their senior tranche, there could be two buckets about this income. One could be the income which they receive as a return on their principal, and one is the repayment of the principal. So ideally, the repayment of the principal is not a taxable income, because you're only getting back what you had invested. So there's no income element involved. And in case of receiving the return on the investment, that is the only taxable proportion. So the investments in PTC needs to be clarified as to the nature of income which should be taxed and which should not be taxed. Right now, there is no such mechanism in place.
Okay, thank you, Priyanka. So I see another question, which is partial assignment of a corporate loan possible? So yes, of course, now securitization of single loans is not permissible, but direct assignment, yes, it would be permissible. But what you have to take care of is, suppose there is a 1,000 crore loan, of which you are assigning 600 crores and retaining 400 crores. The assignee and assigner have to enter into an arrangement that in case there is a default, how are they going to enforce the security? So that is important, because under the Code of Civil Procedure, Order 2, Rule 2, it says that every suit should include the whole of the claim. So if the assignee sues and the other one, the assigner forgets to sue, there could be problems, and the claim could fall away. So both of them have to have a agreement contractually entered into as to how enforcement happens. And there is one question on, it says, apart from home loans, corporate loans, and vehicles, what are the other interesting assets that have been securitized? Yes, so apart from these standard ones, one sees gold loans to securitize, the road project receivables. In the past, of course, cash credit and this one, credit card receivables, but of course that is prohibited now. Now we have also seen once, IPO loans being securitized, because IPO loans, these are basically short-term loans, but there was an investor interest in that, and that was also securitized. So Manish, I can see some questions on direct assignments. So would you like to answer these questions?
Yeah, I will take all these questions. So the first question is an interesting question. So it says, can the consideration in a DA transaction to be paid on deferred basis, or the same can be paid by some other mechanics of swap of assets? Okay, for a DA transaction, one must note that the transaction has to be on cash basis. And one of the element of the direct assignment transaction vis-a-vis a true sale, it is provided that when the loan is being transferred from the assigner to the assignee, the consideration must be discharged at that particular point of time. You can't have an arrangement where you can have a payment of consideration in tranches like that. So the answer is clear that you have to have a cash deal, and the consideration it cannot be paid on a deferred basis. Second question is, are NBFCs and HFCs are covered under IBC? Yeah. Earlier, I think prior to, if I'm not wrong, prior to November 2019, there was no clarity, or rather they are not specifically covered under IBC code. But the government came with a notification in November 2019, where NBFCs, including HFCs, are now covered under IBC, provided I think they have a net asset criteria of 500 crores. So if they are over and above that, they are covered under IBC. Okay, there are three questions typically which are primarily talking about issue of COVID-19 on DA transactions. Okay, I will briefly explain what we are facing in this COVID-19 scenario. One thing which has come to our attention is due to this moratorium announced and due to this COVID-19 position, a lot of assigners came to us and they wanted to say that due to this COVID-19 moratorium, they may have to they might not be receiving that kind of payout which has been agreed in the deed of assignment in the schedule, and does that trigger an event of default per se? Answer to that question is no, it will not trigger an event of default as far as the assigner is concerned, because under a true sale, all risks are of the assignee. If the assigner only has to account for that money to the assignee, which they are actually receiving from the borrowers, they are not going to use their money to recoup any kind of loss for the assignees. Another related question which we have seen, and that this is also raised by one of the attendees, they are saying, can, being the servicer or the originators, can they allow a moratorium on their own announced by RBI? Look, legally, as I already said, that assigner is no more a legal owner of the pool. So when the government of India announced a moratorium of 3 months on EMIs, it is now the call of the assignee how he want to go ahead with that kind of a moratorium. So in practical, we have seen that both the assigner and the assignee have discussed these mechanics, and in many cases they have granted moratorium to all their borrowers across the board, and the monthly payouts are restructured according to that moratorium announced by the government. Having said that, there is an interesting question which comes from the servicers' perspective due to COVID-19. Servicers have come to us and said that due to this unprecedented and difficult times, there is and moratorium announced, a lot of reworking of the payouts are to be done. There might be complications in their receiving money and transferring it to the collection and payment account. Signatories are not readily available. There are a lot of procedural hassles they are facing in actually remitting that money finally to the assignee, though they might be collecting it from the borrowers. It is money lying with them, but due to these lockdown and all these issues, they are facing a challenge how they transfer it on timely basis to all these assignees. So the question comes whether if they delay in making that payment, will that be a event of default? Yes, if you don't have a force majeure clause in your servicing agency agreement to safeguard your interest, if you really default in making the payments to the assignee on the payout date, once you have already received it from the borrower, it may trigger an event of default, and you may have to face the consequences. The consequences may be the assignee may want to terminate the services agreement, take control of everything, or may, if your agreement is providing for any kind of carry forward charges, the assignee may like to impose those carry forward charges on you. So it is also important that everyone from the council side who are drafting these documents, they should ensure that there is a force majeure clause in the servicing agency agreement to safeguard your interest. And now I think going forward, the force majeure clause is also going to be reworked a lot and to cover the pandemic, epidemic, and lockdowns as well. So one must ensure that there is a force majeure clause in servicer agreements, and if it is beyond the control of the servicer, then they may be excused. One question is coming. Okay, what is the cap on the registration charges in the state of Rajasthan? Okay, if you have to register your deed of assignment in the state of Rajasthan, the cap is 3 lakh rupees for the registration of deed of assignment. One more question is there. I think Arnab, this question is for you. I can read out that question so you can answer it. The question says, what will be the position in the light of GST laws if the servicer's fee for servicing the assigned loan pool is clubbed with the consideration of assignment of receivables, and there is no separate identified consideration for the services provided by the servicer in the service agreement?
So
Would you like to take it?
thank you.
Yeah.
Yeah. So it really depends on the wording. If it really says that it is clubbed, so the GST law says that the valuation would have to be somehow computed. Now, when it goes into computation mechanism, it has to basically get into cost plus 10% mechanism. So it will have to be reworked on the basis of cost of servicing that loan on the originator's side. However, that is the reasonable answer. The unreasonable answer might also be that a tax officer takes a view that the entire pool of securitization is applicable to GST, and the logic that he will use for that is that this is basically a mixed supply, which is basically, in which case it is a basket of both exempt supply and a taxable supply, and in those cases the rule provides that the tax rate of the highest tax bracket would basically apply. So that is a scary situation. However, the reasonable answer is definitely a cost plus 10% mechanism to work out the valuation of such services.
Okay. Thank you, Arnab. Just to add on to this, practically we have generally seen that in the service agency agreement, they definitely provide for a consideration to avoid all these complications, I understand, and they're related to some fixed fee or maybe some percentage of the outstanding loan pool. So this is, I think, a safeguard everyone has to take care to avoid any kind of issues by the GST authority.
To supplement that answer, it is always preferable to keep certain value for servicing. It would not be a prudent idea to leave it to these valuation rules and tax officers to come and nitpick in these structures and create a further dispute in this case.
Okay, thank you, Arnab. And I think we have answered certain questions are repetitive, and we have already covered it. If still the attendees feel there are additional questions to be answered, please feel free to drop us an email and we'll definitely try to answer the same. I'll hand over finally to my colleague Sandhya to give the concluding remarks.
Thank you, Manish. We have run out of time. So firstly, I would like to inform all the participants that, if you want a more sort of a nuts and bolts workshop on documentation and securitization or something like that, we can also consider conducting such workshops in smaller groups. If there are any other legal issues where you want to comprehensively discuss the legal and tax issues, we will be able to do so, and please do write to us. So on behalf of myself and Manish and Priyanka and Arnab, I would like to thank all the participants. And with this, I conclude the webinar.
Thanks a lot. Thank you, everyone. Thanks a lot.
Thank you.
Thank you.